The probate hearing hadn't even started when my sister leaned close enough for me to smell her perfume and whispered, "Enjoy your homeless life." She didn't raise her voice. She didn't have to. The words were sharp and quiet, meant just for me. A couple of relatives behind her caught the tone anyway and let out small, satisfied laughs like this was just another round in a long family game. I didn't look at her. The courtroom in Anne Arundel County wasn't dramatic. Beige walls, fluorescent lights, rows of wooden benches that had seen every kind of family disappointment. A few people shifted in their seats. Papers rustled. Someone cleared their throat like they were bored already. My sister Lauren Hale stood perfectly composed in a tailored navy suit. She looked like she was about to close a real estate deal, not argue over our grandfather's estate. She had that same expression she uses at open houses, confident, rehearsed, almost amused. Behind her sat my parents. They didn't step in. They didn't correct her. They didn't even look uncomfortable. My mother kept her lips pressed tight like she was holding in a comment. My father stared ahead at nothing in particular, hands folded. It was the kind of silence that tells you everything you need to know. I kept my hands flat on the table in front of me. Calm, steady. I've spent the last 9 years in the Army. I'm a captain in the Cyber Corps stationed at Fort Meade. I hold a TS/SC I clearance. I've sat in rooms where the stakes were higher than a house in Annapolis. You learn fast that the loudest person usually has the weakest position. Lauren leaned back in her chair and crossed her legs. "You know you can't stay there," she added under her breath, still smiling. I didn't respond. The clerk called the case Estate of Thomas Hale, my grandfather. Hearing his name as that room hit differently than I expected. Not grief exactly, more like someone turning a life into paperwork. The judge entered. Everyone stood. Then we sat. Our attorney, Melissa Grant, organized her files with quiet efficiency. Across from us, Lauren's attorney adjusted his tie and glanced at the stack of documents in front of him, like he was confident he'd already won. The judge reviewed the docket. "I understand there is a dispute regarding occupancy of the residence and allegations of financial exploitation." Lauren's side moved first. Her attorney stood and explained that I had been living in my grandfather's home, and that concerns had been raised about his mental capacity before his passing. He mentioned an emergency petition filed shortly before my grandfather died. He used words like protective action and vulnerable adult. He did not mention that I moved into that house after my grandfather fractured his hip. He did not mention that I took him to every VA appointment for the past year and a half. He did not mention the grocery receipts or the pharmacy pickups or the stack of appointment reminders on my kitchen counter. He did mention that I was in possession of the property. Lauren's eyes flicked toward me again. There it was, that look that says, "You're about to lose." The judge turned his attention to our table. "Captain Hale, do you dispute living at the residence?" "I live there," I said. My voice was even. "With my grandfather's permission." Lauren's attorney stepped in quickly. "There is no written lease, no formal agreement, no lease." That was the angle. The judge nodded slowly and asked the clerk to pull up the estate file. Lauren shifted in her chair, relaxed. She believed the paperwork supported her version. She believed the petition she filed days before our grandfather died was enough to frame the story. She leaned slightly toward me again. "Should have thought about this before you moved in," she murmured. I kept my eyes on the judge. There's something about sitting in a courtroom that changes how you think. It's not about who talks louder. It's about what's on record. The clerk clicked through the system. The faint glow of the monitor reflected in the judge's glasses. The room quieted. I felt my phone buzz once in my purse. I ignored it. I knew what it was. Earlier that week, I'd received an email from the Installation Security Office at Fort Meade. They had been forwarded a complaint through a Department of Defense hotline alleging possible financial misconduct tied to a family estate. Anonymous. Timing like that isn't coincidence. I had already self-reported it to my chain of command. That's what you do when you hold a clearance. You don't wait for someone else to bring it up. My commander had looked at me across his desk and said, "You understand how this could escalate." I did. If a court found that I'd exploited my grandfather financially, that wouldn't just cost me a house. It could cost me my clearance. And without a clearance, I don't have a job. Lauren knew that. That's why she filed the emergency petition. The judge cleared his throat. I see here an emergency conservatorship petition filed 3 days prior to Mr. Hale's death. Lauren's attorney nodded. Yes, Your Honor. Based on concerns regarding capacity and undue influence. Undue influence. Lauren sat straighter. The judge continued scanning. The petition alleges that Captain Hale was exerting pressure and isolating the decedent. That word isolating hung in the air. Isolating while I was driving him to physical therapy twice a week. Isolating while Lauren was showing waterfront condos to strangers. I didn't interrupt. Melissa placed a folder gently in front of me. She didn't need to say anything. We'd already discussed this. I slid one document out and placed it on top of the stack. Your Honor, Melissa said calmly. Before the court proceeds further, we request that this filing be added to the record. Lauren's attorney frowned slightly. What filing? Melissa didn't answer him. She handed it to the clerk. The judge looked at the cover page. His expression didn't change at first. He simply nodded for the clerk to upload it. Lauren's smile tightened. The clerk clicked. The courtroom monitor flickered as the new document loaded into the system. I folded my hands again and waited. The clerk's cursor blinked on the screen while the document finished loading, and I felt every pair of eyes in the room shift forward at the same time. No one knew what was in that file except my attorney and me. The judge adjusted his glasses and leaned closer to the monitor. Lauren's confidence hadn't disappeared, but it tightened. She crossed her arms and angled her body slightly toward her lawyer, as if proximity alone could reinforce her version of events. The judge read silently for a few seconds. Then he looked up. Counsel, he said to Lauren's attorney, this appears to be a directive prepared by the decedent with independent legal counsel. That word independent landed harder than anything else said so far. Lauren's attorney stood halfway out of his chair. Your Honor, we have not reviewed that document. You will, the judge replied evenly. But the court will review it first. The clerk scrolled. I kept my breathing steady. In the Army, you learn how to sit through things without reacting. Briefings, investigations, performance reviews. You don't win by shifting in your chair. The judge continued reading. This filing references an emergency petition submitted days before Mr. Hale's death. Lauren's jaw tightened. The judge's voice stayed calm, but the tone shifted just enough to signal something was off. It further states that Mr. Hale discovered the petition and disputed its contents. Lauren's attorney tried to interject. Your Honor, the petition was filed in good faith based on... The judge raised a hand without looking at him. I will finish. Silence settled again. The clerk scrolled to the next page. The document included an affidavit signed and notarized while my grandfather was still alive. It outlined that he had reviewed the emergency petition and considered it inaccurate. It stated clearly that he had not consented to any conservatorship and that he objected to the characterization of his mental capacity. Lauren shifted in her seat. This wasn't dramatic. No one gasped. No one whispered. But the room felt different. The judge glanced at Lauren. Ms. Hale, were you aware that your father filed this rebuttal through counsel? Lauren's posture stiffened. No, Your Honor. Her answer came fast. Too fast. The judge looked back at the screen. The filing also references a digital audit trail. That was the part Lauren hadn't prepared for. The clerk clicked to the attached exhibit. A basic log summary appeared, timestamp, submission confirmation, verification codes. The judge read it aloud slowly. Petition submitted from residential IP address associated with Ms. Hale's address. Two-factor authentication confirmation sent to a mobile device ending in 4421. Lauren's attorney leaned in toward her. She didn't look at him. My parents sat motionless behind her. The judge didn't accuse. He didn't editorialize. He just read what was in front of him. Verification confirmed within 60 seconds. Lauren cleared her throat. Your Honor, I don't handle technical things myself. My attorney filed the petition. Her attorney's head turned sharply toward her. That wasn't part of their coordinated version. The judge looked between them. The record reflects electronic confirmation tied to a personal device. Lauren's composure slipped for a moment. That doesn't mean. It means, the judge said calmly, that this filing was completed through a process requiring direct confirmation. He didn't raise his voice. He didn't need to. I didn't look at Lauren. I kept my focus forward. The document continued. The clerk scrolled again. Page 3 included something Lauren never expected my grandfather to do. He had outlined in writing that after discovering the emergency petition, he contacted his own attorney to review his estate plan. He expressed concern that the petition misrepresented his condition and stated he felt pressured regarding the property. The judge paused. He states here the judge read that he was concerned about attempts to remove Captain Hale from the residence prior to his passing. Lauren exhaled sharply. That's not what happened. The judge didn't respond to her directly. He continued reading. The affidavit included dates, doctor visits confirming cognitive competence statements from his primary care provider, and documentation that he had independently requested estate revisions. Lauren's attorney stood again, this time more cautiously. Your Honor, even if the decedent disputed aspects of the petition, the question before the court is occupancy and the validity of the will. The judge nodded slowly. And this document speaks directly to both. He leaned back slightly. I felt the weight of the room shift again. Lauren's earlier whisper echoed in my head. Enjoy your homeless life. That line had been built on certainty. She believed the petition would frame me as unstable. She believed the timing would damage my clearance review. She believed the narrative would stick long enough to push me out of the house. Instead, the judge was now reading a document prepared by the one person whose intent mattered most. The clerk scrolled further. The final section referenced an updated estate instrument executed after the emergency petition had been filed. Lauren's head snapped toward the screen. Her attorney's pen stopped moving. The judge read quietly for several seconds before speaking again. This filing indicates that Mr. Hale amended his will following the petition. Lauren's composure cracked slightly. That's not possible. He wasn't. The judge looked up sharply. Ms. Hale. She stopped. The judge's voice stayed level. The record reflects notarization and witness signatures dated after the petition was submitted. He turned to my attorney. Is counsel prepared to authenticate the amended instrument? Melissa stood without hesitation. Yes, Your Honor. Across the aisle, Lauren's attorney shuffled through his folder quickly as if a different outcome might appear between the pages. The judge nodded once. The court will admit the directive and associated exhibits into the record. Lauren stared at the screen, her earlier confidence gone, but not replaced by panic yet. More like calculation. She was adjusting in real time. I kept my hands folded. The judge looked at both parties. This court does not make eviction decisions based on unchallenged allegations. We make them based on verified records. Lauren's attorney attempted one more pivot. Your Honor, our position remains that occupancy should be resolved pending full probate review. The judge's eyes moved back to the monitor. And that review will consider this directive. The clerk clicked again, opening the attached amendment summary. The room grew quiet enough that the hum of the ceiling lights felt louder. Lauren's fingers tightened around the edge of the table. The judge's eyes tracked the first paragraph of the amendment, and his expression changed in a way that was small but unmistakable. The judge's eyes stayed on the screen a second longer than before, and Lauren's breathing grew louder in the silence. He didn't rush. He read every line. This amendment, he said, finally was executed 4 days after the emergency petition was filed. Lauren's attorney shifted in his seat. Your Honor, amendments near end of life can raise concerns regarding influence. The judge looked at him calmly. Concerns are one thing. Evidence is another. The clerk zoomed in on the amendment summary. The heading was simple. First Amendment to Last Will and Testament of Thomas Hale. No dramatic language, just legal text. The judge read aloud the portion that mattered. The residence located in Annapolis, Maryland, is devised in full to my granddaughter, Captain Alexandra Hale. That was the first time my full name had been spoken in that room. Lauren's posture collapsed slightly, then snapped back upright. He wouldn't have done that. Her voice wasn't loud. It wasn't controlled either. The judge continued. The amendment also includes a no contest clause. Lauren's attorney closed his folder slowly. The judge read it clearly so the entire courtroom heard it. Any beneficiary who contests this instrument or attempts to remove Captain Hale from the residence in bad faith shall be deemed to have forfeited their share. The words settled into the air. Lauren stared at the screen like she could will it to change. My parents exchanged a glance for the first time that morning. The judge looked toward Lauren's table. Counsel, were you aware of this amendment? Her attorney hesitated. We were not served with this prior to today. It was filed with this court, the judge replied. That constitutes notice. Lauren leaned forward. He was confused. He wasn't thinking clearly. The judge's tone sharpened slightly. The directive admitted moments ago includes documentation from his physician stating cognitive competence. Lauren's jaw tightened. Doctors don't see everything. I didn't look at her. The judge glanced back at the screen. The amendment further states that it was executed after Mr. Hale discovered the emergency petition. There it was. Lauren's attorney straightened. Your Honor, the petition was filed out of concern for capacity. The judge nodded. And this amendment indicates Mr. Hale disagreed with that assessment. The clerk scrolled to the next exhibit attached to the directive. A summary of the original emergency petition appeared. The judge read key sections aloud. Allegation of undue influence. Allegation of financial exploitation. Request for temporary removal of occupant. The phrase occupant hung in the room. Not granddaughter, not caregiver, occupant. The judge looked at me. Captain Hale, did you have knowledge of this petition before your grandfather's passing? I became aware shortly before he died, I answered. Through whom? Through him. Lauren's fingers curled tightly around a pen. The judge continued. The directive indicates Mr. Hale reviewed the petition and disputed its contents in writing. He turned toward Lauren again. Ms. Hale, did you discuss the petition with your father after filing it? Lauren hesitated. We talked about the contents. We talked about his safety. The judge's expression didn't change. Did you inform him that the petition requested removal of Captain Hale from the residence? Lauren didn't answer immediately. Her attorney stepped in. Your Honor, this line of questioning, it goes directly to intent, the judge said evenly. Lauren exhaled. He knew we were concerned. That was not the question. The judge waited. Lauren's confidence had shifted into something else, now controlled frustration. He knew there were issues. The judge made a note on the file. The clerk scrolled further down the emergency petition summary. A paragraph described alleged financial irregularities. It referenced utility payments and access to household accounts. Lauren's attorney leaned in toward her again. This time, she didn't look at him. The judge's eyes moved back to me. Captain Hale, have you been paying any expenses related to the property? Yes, Your Honor. Utilities and groceries during the time I lived there. From your personal account? Yes. The judge nodded. Lauren interjected again. That's exactly the issue. She controlled everything. The judge raised a hand. Ms. Hale, you filed a petition asserting exploitation. The directive now before the court suggests your father objected to that claim and amended his will accordingly. That is not a minor detail. Lauren's face flushed. The judge turned back to the monitor. This amendment also revises monetary bequests. The clerk zoomed in. My parents leaned forward slightly. The judge read Lauren Hale is to receive a fixed bequest of $15,000. Lauren's head snapped up. My father shifted in his seat. The judge continued. The remainder of the estate assets are to be distributed per the amended schedule. He paused briefly. Lauren's attorney cleared his throat. Your Honor, even if the amendment stands, occupancy remains contested until probate is finalized. The judge nodded. Correct. But a party who files an emergency petition in bad faith does not strengthen her position by doing so. Lauren's voice sharpened. It wasn't bad faith. The judge looked directly at her. The court will determine that. Silence returned. My phone buzzed again in my bag. I ignored it. Earlier that morning, before walking into the courthouse, I had checked my military email. The installation security office had requested additional documentation related to the hotline complaint. They wanted financial statements and clarification regarding the estate. I had already submitted everything, every transfer, every payment, every bank statement. Documentation is not dramatic. It's boring. That's why it works. The judge leaned back in his chair. This court will not issue any removal order today, he said calmly. The directive and amendment materially affect the posture of this case. Lauren's attorney inhaled sharply. Lauren looked stunned. Not shocked, not devastated, just recalculating. The judge turned slightly toward the clerk. Ensure that the directive amendment and associated exhibits are fully entered into the probate record. Yes, Your Honor. The clerk clicked and typed. The judge's gaze moved once more across both tables. This matter will proceed through standard probate review, with all relevant filings considered. Lauren opened her mouth again, but her attorney placed a hand lightly on her forearm. I didn't smile. I didn't shift. I kept my posture steady while the judge reviewed the final page of the amendment. His eyes moved across the last paragraph slowly, and whatever he read there made him pause before setting the file down on the bench. The judge set the file down, and Lauren's attorney leaned toward her, whispering fast, while the clerk finalized the record entry. I stood when the judge rose. Everyone else did the same. The hearing wasn't over in the technical sense, but the direction had shifted enough that even Lauren could feel it. Out in the hallway, the air felt tighter. Lauren stepped toward me immediately. "You blindsided us," I responded. I said. "You manipulated him. That's your version." She took another step closer, lowering her voice. "You think this fixes everything? You think this makes you safe?" The bailiff cleared his throat lightly from a few feet away. That was enough. Lauren stepped back. My attorney moved beside me. "Let's go," she said quietly. We walked toward the exit past relatives who suddenly found their phones very interesting. Outside, the Maryland air felt colder than it should have. I checked my phone as we reached the parking lot. 2 missed calls from installation security. 1 email marked urgent. I opened it. Subject request for clarification. Financial allegation review. The complaint had been formally logged. It referenced the same language as the emergency petition undue influence financial control exploitation of a vulnerable adult. It included the probate case number. Lauren hadn't just tried to remove me from the house. She had tied the allegation directly to my career. I forwarded the email to my commander and typed a short response acknowledging receipt. Then I got into my car. Fort Meade was an hour away with traffic. By the time I reached the installation, I had already decided how this would go. No panic, no defensiveness, just documentation. The next morning, I sat in a small office across from the installation security manager. No dramatic lighting, no interrogation table, just a desk, 2 chairs, and a man who had done this job long enough to recognize patterns. He flipped through the complaint summary. "You self-reported before we contacted you," he said. "Yes, that helps." He looked up. "But you understand why this raises concerns." "I do." He asked about my grandfather's finances, whether I had access to his accounts, whether I benefited financially before his passing. I answered directly. I provided copies of utility bills I paid from my own account. Bank statements showing no transfers from his accounts to mine. Appointment logs from the VA hospital. Emails coordinating his physical therapy. The security manager scanned the documents. "You're up for major this cycle, right?" "Yes." He nodded once. "You know these things can slow down reviews." "I do." He closed the file. "We'll conduct a standard review. As long as the probate record supports your statements and there's no evidence of misuse, this doesn't automatically escalate." Automatically. That word mattered. Nothing about this process was emotional. It was procedural. Outside the building, I sat in my car for a minute before driving home. The house in Annapolis was quiet when I walked in. The same house Lauren had already mentally sold in her head. I set my folder on the kitchen table, the same table where my grandfather used to sort his mail every afternoon. His reading glasses still rested near the salt shaker. I didn't sit long. Instead, I pulled out every document related to his care over the last year. Medical appointment summaries, prescription receipts, copies of checks I had written for utilities when he insisted on paying me back later. I scanned everything. If the Army wanted records, I would give them records. Lauren had assumed the allegation alone would shake me, that I would panic and react, that the word exploitation would stick long enough to damage my clearance. She underestimated how the system actually works. Clearance reviews don't run on emotion. They run on consistency. Later that week, I received notice that the security office had formally requested the probate filings from the county court. They wanted to see the emergency petition and the directive my grandfather filed in response. That part almost made me laugh. Lauren had tried to use the petition as leverage. Now the same petition would be reviewed by people trained to spot inconsistencies. At work, nothing outwardly changed. I still attended morning briefings. I still led my team through defensive cyber analysis. I still signed off on reports that would never be public. But there's a difference between doing your job and wondering whether someone is reviewing your financial history at the same time. My commander called me into his office that Friday. He shut the door. "Security flagged your case for preliminary review," he said. "Yes, sir." He studied me for a moment. "I've read the probate summary, and it looks like a family dispute that escalated." "That's accurate." He leaned back. "You understand how it looks on paper. Allegations of undue influence. Petition for conservatorship. Hotline complaint. Yes, sir. He nodded slowly. Your self-report and documentation work in your favor. But if anything new appears in court, we'll need to know immediately. You will. He didn't soften his tone. He didn't need to. This wasn't personal. When I left his office, I passed 2 junior officers in the hallway. They had no idea what was happening. That's how it should be. At home that night, I checked the county court website. The directive had been fully entered into the probate docket. The amendment to the will was visible in the record summary. Lauren's emergency petition was still there too. Permanent. That's the thing about filings. Once they exist, they don't disappear just because someone regrets them. A few days later, my attorney called. The other side filed a response, she said. To what? To the directive. They're challenging intent. On what grounds? They're arguing capacity and influence. Of course they were. Capacity had been their original angle. Anything new, I asked. Not yet. But they're pressing. I hung up and looked around the house. Lauren had believed she could force a fast removal order before the probate process caught up. When that didn't work, she shifted to contesting the amendment. The clearance review remained open. The probate case remained active. Nothing had exploded. Nothing had collapsed. It was just pressure steady and controlled. I walked into my grandfather's old study and opened the drawer beneath the bookshelf. Inside was a small fireproof lockbox. I lifted it out and set it on the desk. The combination hadn't changed. Inside were copies of older estate documents and a handwritten list in his neat block letters inventory notes he kept updated over the years. He had always believed in records. I closed the box and returned it to the drawer. The next morning, my phone buzzed again while I was reviewing emails. A calendar invite from Installation Security appeared on my screen. Follow-up review. Financial allegation. Scheduled for Monday at 900. I tapped accept. I showed up to the follow-up review 10 minutes early with a folder thicker than it needed to be. The security manager didn't waste time. He had the probate filings printed and highlighted. We reviewed the emergency petition, he said. Walk me through your understanding of why it was filed. Lauren believed our grandfather was being influenced, I answered. She also believed I shouldn't be living in the house. That's the polite version. Yes. He flipped to the directive filed by my grandfather's attorney. This document directly contradicts the petition. It does. He tapped the page where the audit trail summary was attached. We also reviewed the digital verification attached to the petition. That was the part that mattered most. 2-factor confirmation tied to your sister's number, he continued. Yes. He leaned back in his chair. That complicates her position. It also complicated the narrative she had tried to send through the hotline. The security office had already requested clarification from the Department of Defense hotline unit regarding the origin of the anonymous complaint. While anonymous tips aren't unusual, the timing relative to the petition raised questions. You have any financial transfers from your grandfather to you in the last 18 months, he asked. No. Joint accounts? No. Power of attorney? No. He nodded once and made a note. Your documentation aligns with the court record, he said finally. We'll finalize our internal summary after probate progresses. Understood. When I walked out of that office, the pressure didn't disappear. It shifted. This was no longer about panic. It was about precision. Later that afternoon, my attorney called again. They've filed a supplemental brief, she said, challenging the amendment. Yes, they're arguing that the directive and the amendment were reactions to stress. Stress. They're implying your grandfather was pressured after seeing the petition. I let that sit for a moment. So now filing a petition and being told it exists counts as pressure, I asked. Essentially. We reviewed the timeline carefully. Petition filed. Grandfather notified. Grandfather contacted his own attorney. Directive prepared. Amendment executed with witnesses, filed with the court. It wasn't rushed. It wasn't impulsive. It was documented. The judge already admitted the directive, she reminded me. But they're trying to reframe motive. Of course they were. A week later, we were back in the same courtroom. This time the tension felt different. Less smugness from Lauren. More calculation. The judge entered and reviewed the supplemental filings. Lauren's attorney argued that emotional strain near end of life could affect decision-making. He referenced the petition as evidence of family conflict and implied that conflict influenced the amendment. The judge listened without interruption. When it was our turn, Melissa stood and addressed the court clearly. The amendment was executed with independent counsel and 2 witnesses. The physician's letter confirming capacity was attached. The directive explicitly states Mr. Hale objected to the emergency petition and sought to clarify his intent. She didn't dramatize it. She didn't overplay it. She simply placed the facts in order. Lauren watched the judge carefully. The clerk pulled up the directive again on the courtroom monitor. There it was, emergency directive and declaration of Thomas Hale, the same file that shifted everything before. The judge leaned forward. "I want the audit trail displayed again," he said. The clerk clicked. The log summary appeared on the screen: submission timestamp, IP address, 2-factor confirmation code verification complete. The judge read the confirmation line slowly. Verification sent to device, ending in 4421. Lauren's attorney shifted in his seat. The judge looked toward Lauren. "Is that your number?" Lauren hesitated. "Yes." "And you confirmed the petition?" "I confirmed what my attorney prepared." "So you personally authorized the submission?" She looked toward her attorney again. He remained silent this time. "Yes," she said. The courtroom didn't react, but something had just locked into place. The judge nodded slightly and turned back to the screen. Now he continued. The directive states Mr. Hale was informed of the petition and objected to it. He flipped to the physician's letter attached to the amendment. Capacity confirmed. No cognitive impairment noted. Lauren's argument about confusion was thinning. Her attorney tried again. "Your Honor, even competent individuals can be influenced under emotional strain." "Of course," the judge replied calmly, "which is why the court reviews documentation, not speculation." He paused, then added, "And documentation here is substantial." The clerk scrolled to the portion of the amendment referencing the no contest clause. The judge read it again, this time emphasizing the language about bad faith attempts to remove the beneficiary from the residence. Lauren sat very still. The judge leaned back. "Counsel," he said to Lauren's attorney, "your client initiated an emergency filing alleging exploitation. The decedent responded in writing under oath with counsel, amending his will and documenting his intent. That sequence matters." Lauren's attorney nodded slowly. He had no immediate counter. The judge continued. "This court does not disregard contemporaneous documentation absent clear evidence of fraud or incapacity." He closed the file. The silence that followed wasn't dramatic. It was procedural. Lauren's eyes flicked briefly toward me, but the earlier certainty was gone. In its place was something tighter awareness that the record was not on her side. The judge turned to the clerk. "Ensure that the audit log and amendment remain attached to the docket for final probate review." "Yes, Your Honor." He looked once more across both tables. Unless either party has new evidence directly challenging capacity or authenticity, this court sees no basis to invalidate the amendment. Lauren's attorney glanced down at his folder. He didn't stand. I kept my posture neutral. The judge made a final note on the bench sheet and set his pen down. The judge's pen rested on the bench while Lauren's attorney searched his folder for something that wasn't there. The courtroom felt smaller now. "Your Honor," he began carefully, "we maintain that the emergency petition was filed out of genuine concern." The judge nodded once. "Concern does not excuse inaccuracies." He turned back to the screen. "Let's address the technical record clearly." The clerk enlarged the audit summary again. Submission time. Residential IP address. 2-factor authentication sent. Confirmation received. The judge looked directly at Lauren. "You personally confirmed the filing through your device." "Yes," she answered. "You understood that the petition alleged financial exploitation." "Yes." "You understood it requested temporary removal of Captain Hale from the residence." Lauren hesitated. "It requested protective action." The judge's tone stayed even. "Removal from the residence qualifies as protective action in your view." Her attorney shifted in his chair. Lauren's voice lost its polish. "We were trying to protect him." "From whom?" the judge asked. The question hung. Lauren didn't answer immediately. The judge didn't press harder. He simply returned to the document. "This log reflects confirmation from your personal device within 60 seconds, he said. "That is not accidental." Her attorney stepped in. "Your Honor, we are not disputing that my client authorized the filing. We are disputing the implication of bad faith." The judge leaned back slightly. "Bad faith is determined by intent and outcome." The decedent responded in writing, amended his will, and documented objection to the filing. He paused. Those facts are difficult to ignore. Lauren's composure cracked just enough to show strain. He overreacted. The judge looked at her directly. Your father amended his estate plan 4 days after your petition. Silence again. The clerk scrolled to the section of the directive referencing the locksmith quote. The judge read it aloud. Email correspondence requesting a lock change for the residence dated 1 day after the emergency petition. Lauren's attorney stiffened. Your Honor, that was merely exploratory. Exploratory, the judge repeated calmly. The quote includes the address and a request for access. Lauren's face flushed. It was precautionary, she said. For a petition that had not yet been heard, the judge asked. Her attorney opened his mouth and closed it. The judge looked at the document once more. The timing is notable. He didn't need to elaborate. I remained still. Lauren had built her position on urgency, on portraying the situation as immediate danger. But urgency without evidence becomes exposure when the timeline is reviewed line by line. The judge closed the audit summary and turned to both tables. This court does not determine criminal liability, he said. But it does recognize when filings affect estate distribution. Lauren's attorney straightened. Your Honor, we are not conceding any wrongdoing. You are not required to, the judge replied. The record speaks for itself. He made another note on the bench sheet. The tension in the room wasn't loud, it was compressed. The judge shifted his focus. We will now address distribution and occupancy pending final probate closure. Lauren inhaled sharply. The judge looked at the amendment again. The residence is devised to Captain Hale. He glanced toward Lauren's attorney. Your challenge to capacity has not met the threshold required to invalidate the amendment. Lauren leaned toward her lawyer and whispered something too low to hear. He shook his head slightly. The judge continued. Occupancy shall remain unchanged. That was the practical outcome Lauren had tried to prevent. No eviction order, no removal. The petition she filed to push me out of the house had not achieved its goal. The judge folded his hands on the bench. Additionally, he said the court will note the sequence of filings in the record for consideration of potential fee allocation. Lauren's attorney stiffened at that. Fee allocation meant legal costs. The judge didn't elaborate further. He simply returned to the docket summary and scanned the final entries. In that moment, my phone vibrated again in my purse. I didn't check it. Not yet. The judge looked once more at Lauren. Ms. Hale, he said calmly. When you filed the emergency petition, did you believe your father lacked capacity? Yes. And you maintained that belief after he filed a written directive disputing your claims. Lauren hesitated. I thought he was being influenced, she said. By whom? She glanced at me. The judge followed her gaze. He didn't comment. He didn't need to. The silence itself did the work. Lauren's narrative depended on portraying me as controlling and secretive. But the audit log showed who initiated the legal action. The directive showed who objected. The amendment showed who clarified intent. The paper trail was linear. The judge finally closed the file completely. The court will proceed with formal probate administration in accordance with the amended will, he said. Lauren's shoulders tightened. Her attorney leaned in again. We may consider further review options. You are entitled to do so, the judge replied. Within the bounds of the law. He looked toward the clerk. Ensure that all exhibits remain attached to the official record. Yes, Your Honor. The judge stood. Everyone else stood with him. As we gathered our documents, Lauren remained seated for a moment longer than necessary. Her confidence from the first hearing when she leaned in and whispered about homelessness was gone. But she wasn't finished. She stood slowly smoothing her jacket as if the appearance of control might restore it. When we stepped into the hallway again, she approached me immediately. You think this is over? She asked quietly. I adjusted the strap of my bag on my shoulder. I think the record is clear, I replied. She studied my face for any sign of uncertainty. There's still the hotline complaint, she said. I know. Her expression shifted not triumph, but calculation. I didn't make that up, she added. I know you didn't, I said. Because she didn't need to. She filed the petition. The system did the rest. I walked past her toward the courthouse exit. My phone vibrated again. This time I checked it. A new message from Installation Security had just come through. I unlocked my phone in the courthouse parking lot and opened the message from Installation Security. Subject line: probate filing reviewed. Additional documentation attached. I read it once, then again more slowly. The security office had received certified copies of the probate filings, including the emergency petition, the directive, and the amended will. They noted that the digital audit trail and physician letter were now part of the official court record. They also requested one more item confirmation of whether any recorded statements existed from my grandfather regarding the dispute. I stared at that line for a few seconds. There was one. It hadn't been introduced in open court yet, because it wasn't necessary for admission of the amendment. The directive and the physician's statement had been enough. But my grandfather had recorded something with his attorney the week after the petition was filed. Not dramatic, not emotional, just clear. I called Melissa. "They're asking about recorded statements," I said. She didn't sound surprised. "We expected that." "It's time. It's appropriate," she replied. "Especially if Lauren continues challenging intent." The next hearing wasn't weeks away. It was scheduled quickly after Lauren's supplemental filing. Probate judges prefer clean records. When we returned to the same courtroom, Lauren looked more controlled than before. Not confident. Controlled. The difference is subtle but real. Her attorney had filed another argument this time, focused on emotional pressure. He implied that my grandfather amended his will because of family conflict, not because of clarity. The judge listened again without interrupting. When it was our turn, Melissa stood and addressed the court plainly. "Your Honor, in addition to the directive and the physician's letter, we are prepared to authenticate a recorded affidavit made by Mr. Hale in the presence of his attorney." Lauren's head snapped slightly toward our table. Her attorney stiffened. The judge looked at Melissa. "Is this recording referenced in the directive?" "Yes, Your Honor. It was prepared the same week." "Is it properly preserved?" "It is." The judge nodded. "Proceed." The clerk connected the courtroom speakers. There was no dramatics buildup, no cinematic pause, just a click. My grandfather's voice filled the room. "This is Thomas Hale. Today is March 12th. I am recording this statement with my attorney present." His voice was steady, clear, not confused. "I have reviewed a petition filed by my daughter alleging that I am unable to manage my affairs and that my granddaughter is exerting undue influence." Lauren's breathing became audible in the silence. "I disagree with the contents of that petition," he continued. "I am of sound mind. I have consulted my physician and I have met with counsel." The recording wasn't long. It didn't wander. "I amended my will because I want clarity. I do not want my granddaughter removed from my home. She lives here at my request. She assists me because I asked her to." He paused briefly. "I am aware that the petition requests her removal and implies financial misconduct. I have seen no evidence of that." Lauren's attorney shifted uncomfortably. My grandfather's tone hardened slightly. "If my estate plan is contested based on claims I have already disputed, I want the court to understand that those claims were not made with my consent." The recording ended. No applause, no reaction, just the quiet weight of his voice lingering in the room. The judge leaned back in his chair and folded his hands. "Is this recording authenticated?" he asked. "Yes, Your Honor," Melissa said. "We have the original file and metadata confirmation. It was prepared in counsel's office." Lauren's attorney stood slowly. "Your Honor, recordings can be influenced by context. Emotional stress." The judge raised a hand. "The decedent clearly states awareness of the petition and intent to amend his will." He turned toward Lauren. "Ms. Hale, were you aware that your father recorded this statement?" Lauren didn't answer immediately. "No," she said finally. The judge looked back at the bench file. "This recording aligns with the directive and the physician's letter. He didn't need to add more." Lauren tried one last angle. "He felt attacked," she said. "Of course he reacted." The judge's tone remained calm. "He reacted by consulting counsel and documenting his intent. That is not irrational." Lauren's face flushed again. The judge turned to the clerk. "Enter the recording transcript into the record." The clerk nodded and began typing. The courtroom felt different now. Before this had been a dispute over occupancy and paperwork. Now it was something else, a documented response by a competent man who anticipated exactly what would happen after his death. The judge addressed both sides. "This court has now reviewed the petition, the directive, the amendment, the physician's letter, and the recorded affidavit. The decedent's intent appears consistent across all documents." Lauren's attorney exhaled slowly. The judge continued. "Challenges based on generalized claims of emotional influence are insufficient without contradictory evidence." He made another note. Lauren stared at the table. The no contest clause remained in place. The amendment remained valid. The directive remained part of the record. The judge looked up one final time. Unless additional evidence of incapacity is presented, the amended will stands. Lauren's attorney did not stand again. The hearing moved forward into administrative matters deadlines, inventory submission, estate accounting. Routine steps. But routine steps matter. As we gathered our files, Lauren remained seated longer than usual. When she finally stood, she didn't look at me. Outside the courtroom, the hallway was quieter than it had been on previous hearings. Lauren stepped toward me again. "You turned him against us," she said. "I didn't," I replied. "He made his own decisions." She studied my face, searching for something, guilt maybe. Doubt. She didn't find it. "There are other ways to challenge this," she said. "You're free to try." She shook her head once, not in denial but in frustration. I walked past her and toward the exit. My phone buzzed again. This time it wasn't from Installation Security. It was an email from the county clerk's office confirming that the recording transcript had been formally entered into the probate docket. Permanent. I parked outside the Installation Security building and sat in my car for a full minute before turning off the engine. The final documentation had been filed in probate. The no contest clause was officially triggered. The estate accounting was moving forward. But none of that mattered to the Army until they finished their own review. Inside, the same security manager met me with a thinner file than before. "We've reviewed the complete probate record," he said. I nodded. "The directive, the amendment, the recording, the audit logs." "Yes." He closed the folder and rested both hands on top of it. "There is no evidence of financial exploitation." The sentence was direct, no buildup. "Based on the documentation and your self-report, we are closing this review with no adverse action." I felt the tension in my shoulders release slightly, not dramatically, just enough to notice. He continued, "You handled this correctly. You reported immediately. You provided full documentation." "Thank you." He nodded once. "You understand that hotline complaints can still be investigated if new information appears." "I do. But as of now, there is no clearance impact." Clearance impact. That was the phrase that mattered most. I walked out of that office and into the afternoon sunlight with the kind of quiet relief that doesn't look like relief at all. At work, nothing changed. No announcement. No acknowledgement. I returned to my desk, logged into the classified system, and continued reviewing tasking orders. That's the thing about military life. Your personal crises don't pause the mission. Later that week, Melissa called again. "The judge has formally referred the emergency petition for review regarding potential misrepresentation," she said, "to the state's attorney." "Yes. It's standard when a filing raises concerns about accuracy." "Is it criminal?" "It's an evaluation." That's all for now. That was realistic. Judges don't throw people in jail from the bench. They document and refer. Lauren's attorney had tried to downplay the referral in his follow-up communication, framing it as procedural. But referrals create records, and records create scrutiny. A few days later, Lauren called me for the first time since the last hearing. I almost let it go to voicemail. I answered. "You asked for this," she said immediately. "I asked for documentation. You made it look like I committed fraud. I didn't make you file anything." Silence on the other end. "You could have just agreed to sell the house," she continued. "We could have split it and avoided all of this." That wasn't his plan. It was practical. It wasn't his. Her tone shifted from anger to something closer to frustration. "You always do this." "Do what?" "Stand there calm while everyone else pays for it." "I paid for it too," I said. "Clearance reviews aren't pleasant. Neither are court hearings." She exhaled sharply. "They contacted me." "The state's attorney?" "Yes, that made sense. Once a referral is logged, someone reviews the filing timeline and supporting documentation." "What did they ask?" I said. "Questions about the petition. About the locksmith quote. About the hotline complaint." The locksmith quote. I hadn't even needed to mention it outside of court. The directive had already attached it. "You requested a lock change before any court order," I said. "It was precautionary." "That's what you said in court." She didn't respond. "They're treating this like I lied," she said finally. "Did you?" I was trying to protect him. The line sounded weaker this time. I didn't argue. The call ended without resolution. That evening I reviewed the promotion board schedule posted internally. Results would be released within a month. Promotion to major is not automatic. It's competitive. Records matter. Clearance matters. Even though the review had closed, the timing of the allegations still sat in my mind. If Lauren's petition had been filed without my knowledge, without the directive, without the amendment, it could have looked very different. Documentation doesn't just protect you in court. It protects you in silence. 2 weeks later, Melissa emailed me a copy of the state's attorney's preliminary findings. The referral had not resulted in felony charges. Instead, it focused on potential misrepresentation in the emergency petition. The matter was being handled through a negotiated resolution, likely probation, and formal acknowledgement of inaccuracies. Realistic, proportionate. Lauren wasn't going to prison. She wasn't going to disappear. But the filing would remain part of the record. Permanent. I walked through the house that night, slowly checking the locks without thinking about it. The locksmith quote had been precautionary. That was the word she used. The new locks I installed after the first hearing were not precautionary. They were practical. On the kitchen counter, my phone buzzed with a new email notification. Subject line: promotion board results. Restricted access. My heart rate didn't spike. It just steadied. I opened the message. It required secure login through the internal system. I set my phone down. There's a strange calm that comes when you realize you've done everything you can. The rest isn't yours to control. I logged into the secure portal and entered my credentials. The screen loaded slowly. The results page finished loading, and I scanned for my name. The same way I scan for threat indicators, methodically, without letting hope interfere with accuracy. Captain Alexandra Hale. Selected for promotion to major. No fireworks, no music, just a line of text. I read it twice to be sure. The clearance review had closed with no adverse action. The probate court had upheld the amendment. The no contest clause stood. And now the promotion board had made its decision. I closed the portal and set my phone down on the kitchen counter. There was no one at the house to react. No applause, also speech. Just the quiet hum of the refrigerator and the faint ticking of the wall clock my grandfather had insisted on repairing himself every year. The final probate hearing came a few weeks later. It wasn't dramatic. It was procedural. The estate inventory had been filed. The distribution schedule confirmed. The no contest clause had been triggered based on the court's prior findings. Attorney's fees had been allocated in part to the estate due to the emergency petition. Lauren sat straighter than usual, but she didn't argue. Her attorney confirmed on the record that they would not pursue further challenge to the amendment. The judge nodded. The amended will stands. Distribution shall proceed accordingly. He didn't lecture. He didn't scold. He simply formalized what the documents had already made clear. The residence was legally mine. Lauren's fixed bequest remained limited as outlined in the amendment. My parents' shares were unaffected beyond the standard distribution. The judge closed the file. That was it. Outside the courthouse, Lauren approached me one last time. "You're satisfied?" she asked. Satisfied isn't the word. What is resolved? She shook her head slowly. "You think this was about the house?" "It was about the house," I said. "It was about fairness. It was about intent." She stared at me for a long moment. "You could have worked with me. You filed a petition asking a court to remove me from my own home. I thought you were controlling him. You thought I was in the way." Her jaw tightened. "They're putting me on probation," she said quietly. "I know." The state's attorney had resolved the referral through a negotiated agreement. It required acknowledgement that the emergency petition contained unsupported allegations and that no locksmith action would be taken without court authority. It wasn't prison. It wasn't dramatic. It was official. "You didn't have to push it that far," she said. "I didn't push it." She studied my face again. "You always stay calm," she muttered. "Like you're above it." "I'm not above it," I said. "I'm just not reacting the way you expect." She didn't answer. My parents lingered near the courthouse doors. My father finally walked over. "It's done," he said quietly. "Yes." He nodded once. He didn't apologize. He didn't defend Lauren. He simply accepted the outcome. That was enough. Back at the house in Annapolis, I walked through each room slowly. The probate paperwork had been filed with the county. The deed transfer documentation was scheduled for recording. The inventory list my grandfather kept was now stored in a fireproof safe in the study. I replaced the locks the week after the first hearing. I installed a doorbell camera. Not because I expected trouble, but because documentation works best when it's consistent. The Army updated my official records 2 weeks later. Rank Major. The change looked small in the personnel system. Just a single line updated. But it represented years of work deployments, evaluations, and responsibility. Lauren texted once more after everything closed. "You ruined my life." I read it without responding, because that wasn't true. She filed the petition. She confirmed the verification code. She requested the locksmith quote. She sent the hotline complaint. The record reflected her choices, not mine. That night I sat at the same kitchen table where my grandfather used to review his mail. The same table where he signed the directive and met with his attorney. The same table where I sorted his medication and stacked VA appointment cards. I didn't celebrate. I didn't feel vindicated. I felt steady. The house wasn't a trophy. It was responsibility. The promotion wasn't revenge. It was earned. Family revenge stories usually end with shouting or collapse. This one ended with paperwork signatures and quiet confirmations in official systems. Lauren believed that one emergency petition would push me out of the house and shake my career. Instead, one file changed everything. The directive she never expected. The amendment she didn't read carefully. The audit log she couldn't explain away. And the clearance review she tried to trigger. I stood up from the table and walked to the study, opening the drawer beneath the bookshelf one more time. The fireproof box sat where it always had. Inside were copies of the directive, the amendment, and the probate order. Permanent. I closed the drawer and turned off the lights. No one clapped. No one apologized. But no one could tell me to enjoy being homeless again. I locked the front door that night without checking it twice. Not because I was careless. Because I didn't have to prove anything anymore. What happened in that courtroom wasn't about winning an argument. It wasn't about embarrassing my sister. And it definitely wasn't about revenge in the loud, dramatic way people expect from family drama. It was about documentation. She yelled. She filed. She tried to control the story. I stayed quiet. I reported everything. I let the record speak. Family revenge stories don't always end with someone getting dragged out in handcuffs. Sometimes they end with a judge reading a file, a clearance review closing, and a promotion going through exactly as it should. If you've ever dealt with family betrayal, inheritance disputes, or someone trying to weaponize the legal system against you, you already know this emotion fades, but paperwork stays. And when the paperwork is on your side, you don't need to raise your voice. If you enjoy real family drama, legal reversals, and grounded revenge stories rooted in military life and real-world consequences, make sure you subscribe to the channel. There's more coming.